Good morning and good afternoon. My name is Kathleen Regan, and I'd like to welcome you all to a LexisNexis complimentary CLE eligible webinar titled Privacy Implications for Smart Devices and Social Media in the Workplace. Before introducing our speakers, we have a few announcements. If you have access to live streaming, we would encourage you to use that method to participate in today's webinar. Please take note of the survey that is available to you. We ask that you please complete it, as it provides excellent feedback for us so we may continue to bring you outstanding programs that meet your needs. Also, we have a complimentary Neely's Data Privacy Report available to our attendees today. This report can be found in the handout widget of your console. The panelists welcome your questions. You can submit your questions via the Q&A section of the platform throughout our program today. The panelists will try to address as many audience questions as possible. Please keep in mind all questions may not be answered due to time constraints. No questions will be asked verbally and instead should be submitted using the Q&A section of the platform. For CLE accreditation, we will announce 2 5-digit codes randomly throughout today's call. After today's call, you will receive an email from LexisNexis within 48 hours that will direct you to download your CLE certificate from LexisNexis University using the participant codes provided today. Should you have any questions, please contact the LexisNexis CLE team at cle@lexisnexis.com. And now I'd like to introduce our speakers. Complete biographies are included with today's PowerPoint. Fallon Brattle is an associate in the Nashville office of Nelson, Mullins, Riley, and Scarborough. She concentrates her practice in corporate, tax, and technology law. Ms. Brattle has experience advising clients on a wide range of complex commercial transactions. David Katz is a partner in Nelson, Mullins, Riley, and Scarborough's Atlanta office, where he leads the Privacy and Information Security Practice Group. He provides legal advice on matters to the privacy laws affecting multiple sectors of the economy. Heidi Wachs is a member of Jenner & Block's Privacy and Information Governance Practice, a nationally recognized leader in privacy, breach response, and data security compliance. Her wealth of experience includes serving as a privacy researcher and as Chief Privacy Officer of a major university. Brock Wanless is Assistant General Counsel at Groupon, with increased responsibility for global privacy and regulatory initiatives. He is the chair of Groupon's Global Privacy and Regulatory Working Group that coordinates and implements global privacy and regulatory initiatives. And now I'd like to turn the program over to our speakers. The floor is yours.
Hi everyone, this is Fallon Brattle, and we would not be lawyers if we didn't begin by sharing this quick disclaimer with you. The content shared here in this presentation has not been reviewed or approved by our respective firms or companies before being presented here to you today. So it does not necessarily represent the views and opinions of these organizations. The presenters express personal opinions and not legal opinions, and disclaim any and all legal responsibility and liability for personal comments shared in this presentation. This is an advertisement. So without further ado, we can get started with the presentation. The first topic that I'm going to discuss is social media policies versus social media strategy, and why both are necessary to adequately prepare and protect a business in the internet world. Just to back up a little bit, as Kathleen mentioned, I've helped several large companies with technology-related initiatives, including most largely outsourcing, but also in the development and implementation of policies and strategies, what I like to call a social media playbook that relates to the use of social media in the workplace and in customer and client interactions. Social media law is also a very close cousin to advertising and promotions law. So you should probably be aware that whenever a company or a brand uses the internet to increase awareness of its products or otherwise boost sales or positive associations with the brand, that it's still advertising and marketing, and so those rules generally come into play as well. let's get into the main slide here. I'm going to start the discussion with what type of information or planning should be the basis behind social media policies versus social media strategies. And each of these should be a document, documents held within most companies or corporations. So let's start with social media policy. A social media policy tells employees and employers how social media should be utilized on a practical level as it relates to the business. No matter the size of the business, a social media policy is great to have because it takes the guesswork out of the type of social media interactions that a company approves versus what the company does not approve of. These policies are typically twofold in that they address an employee's personal use of social media. For example, how the employee uses social media on company computers or while conducting company business. Or perhaps the employee uses his personal social media accounts to discuss information that impacts the business, or even if an employee is saying nice things about the company that he or she works for. As you'll later see, there are legal guidelines, especially from an FTC standpoint, that these posts need to follow. The second fold of a social media policy deals with employees' use of social media on the company's behalf. If any business allows its brand to be portrayed on social media or anywhere else on the internet, and the development or maintenance of that content is in the hands of an employee or a team of employees, then there needs to be concrete policies in place for these employees to follow and to become familiar with in order to govern what should be done or should be said on behalf of the company. It's really easy to think that an employee can use his or her best judgment and that will be enough. But as we've seen lately, and as recently as earlier this month, the FTC updated its guidelines about advertising and promotions using the internet. We'll see that there will probably be a trend of an increased crackdown by the FTC on these types of advertisements and promotions and basically what a company says online about its company or about its products. So an established media policy, social media policy, is a great document to also bridge the knowledge gap between employees within a marketing role or team. As employees come and go, as they transition in and out of the company, an established social media policy will help establish and maintain continuity in the company's social media message. And also on a practical level, it can aid in the exchange of protected company information related to social media, such as passwords, account information. I know Facebook has a special feature where you can pay to advertise with Facebook. All of that information should be included within the social media policy that a marketing team would use, for example, so that it would make it easy to pass this information between employees. As you see here on this slide, a social media policy tends to walk a fine line because on the personal side, as I originally discussed, it shouldn't be so restrictive that you violate an employee's freedom of speech, but on the business side, you should be clear about the company's authorized procedures as well as the do's and don'ts of social media use. So in contrast to the social media policy, we also have social media strategy. Here's the difference between the two. While the policy deals with the specifics of what you should or should not do on social media relating to a business, the strategy comes from the approach of what would our business look like if we got social media totally right, and it aids in the bottom line. It increases awareness about our brand and our product, and it's just awesome. What would we want that to look like? And then there's also the flip side of what would we do in the instance that social media went totally wrong for us. Like, what if something absolutely awful happened? So a good social media strategy is pretty much the written marching orders for how a company will accomplish its goals related to sales or customer interactions or brand management through use of the internet. But as you can probably guess, the social media policy kind of gets in the weeds, but the strategy is more of a high-level document, and it needs to be put together by company leadership and really embraced by company leadership in order to become more effectively implemented within the ranks of an organization. In my experience, you can have a social media policy, but if leadership doesn't really place a value on the policy or on having a strategy that, if leadership doesn't really place a focus on social media at all, then it's kind of like you have a policy, but what's the purpose of it? So for social media strategy, it really is a top-down type of document, and it really will aid in having effective policies implemented throughout the organization. When there's a general acceptance and understanding of what the company's goals are related to social media, then the business units can then create marketing campaigns or new products or, awesome ways of communicating with customers via social media that reinforces the company's goals, and then everyone wins. So now, one other thing about the social media strategy is that it also should address crisis management, which is, how do we approach an internet backlash? What if there is your company stinks hashtag that's trending on Twitter? Or what happens if a customer starts a Facebook group to discuss a bad experience that they had with your company? Recently, I saw on Twitter where a customer from a restaurant had posted a picture of his chicken tender that vaguely resembled a rodent, a deep-fried rodent, and it was trending. I saw it on Huffington Post. It was on Twitter, and the company immediately issued a response like, this is typical for chicken tenders to have different shapes, and we definitely do quality control, and this is not something that shouldn't be in your food, and it's okay to eat here. So that company had to have already had a crisis management plan in place, a document that kind of allowed people whose roles it is to interact with the community via social media to just basically take it and implement it because it was already there. Like when a crisis happens, it's no time to kind of scramble and try to figure out exactly what you want to do. So we see now that the social media strategy is a great place to set forth the what-if protocols, and it's also a good place to express a general hierarchy or chain of command for escalating an issue that's not specifically addressed within the social media policy. Next, I'm going to discuss privacy considerations for the use of social media in hiring decisions. Here we'll deal with the law regarding social media searches, equal opportunity laws, and general takeaways. Although today, and I say today because of course the law is always changing, there are no specific federal laws that focus on the regulation of an employer's use of employee social media posts and hiring decisions. And that's a really long sentence because there are certain federal rules that say, that governs whether or not you can access an employee's social media account. But what I'm dealing with here is, if you were to log on to your personal Facebook account and Google someone or Facebook search someone who is set to interview with your company, what would you find? So this is dealing with, what's public, what's out there already on the internet that you could obtain legally without, hacking into someone's Facebook account or even asking them to provide you with the passwords. Because I know there are, certain laws that restrict an employer even being able to ask someone to provide their account information. So coming from the perspective of a perfectly legal Google search or Facebook search or Twitter search, what can or can't you do as an employer when considering someone for a hiring decision? I would encourage each of you to do a bit of research on your own or either engage local counsel if this is a large part of your business or part of the business of a company that you work with, to share the details of any social media or privacy-related laws within state jurisdictions, because there tend to be a lot of states that have special considerations that you may need to be aware of. For example, some states require companies to get express permission from a candidate before conducting a formal social media search. Others require that information discovered from the search is treated with the same privacy considerations as that of a consumer credit report, which we know that's been a highly contentious area in terms of using someone's credit score and other quote-unquote non-relevant factors in making hiring decisions. Many states that allow information from searches to be used then require that the candidates are given ample opportunity to review the report and to rebut any information that they find to be untrue or misleading. So it's really important to keep state considerations in mind because they vary vastly between the states, and so that's really something that you should know, that you should be aware of for your particular jurisdiction.
Sorry, this is Heidi. I just want to chime in for a second there on that, just to reinforce what Fallon said on the state law. There's actually, it started a couple of years ago, a trend towards state legislation that specifically prohibits employers asking for social media credentials from applicants. And so if that is, again, something that you're doing as part of your practice, you're going to want to not only check the current status of the states that you're operating in, but also keep track of that, because it was sort of viewed as something that might have been a short-term fad, but it seems to be here for the long haul, and over time more and more states are passing this type of legislation.
Yeah, that's a great point, Heidi. So now I'm going to move on a little bit to just touch on equal opportunity laws. So if social media searches are something that a business would like to include in its hiring process, then there are some practical steps that the company may need to take within its own ranks and particularly within its HR function in implementing something like that. The goal here is to avoid the use of information about a candidate that could lead to accusations of violations of equal opportunity laws. So one way to mitigate this problem is to create an HR function that reviews the social media information. So this way, those who do the searches are kept separate from those that make the hiring decision, and the people who review the information can kind of know, like, okay, this information isn't relevant at all, like this information you shouldn't use, or, you know, it relates to issues of gender or race or disability or something like that. And that way, those making the hiring decisions are basically shielded behind the wall of not even knowing the information that they probably don't need in making their hiring decisions in the first place. To the general takeaways here. Aside from making sure that, you know, you want to keep a separate HR function and really have everyone understand, you know, what the goal of using social media in these searches, in hiring decisions will be, the key here is to be consistent. This goes back to the beginning of my presentation of talking about creating a social media policy that your employees or that the employees of the company really understand, because you want to be consistent and you want, if you're going to use social media in a hiring decision, you want to make sure you're using it in the same way for everyone. So make sure that not only that the adequate procedures and policies are in place, but that they are enforced consistently across, you know, hiring for different divisions within the organization or for different, in different capacities, that it's pretty much this is the company policy and this is enforced consistently across the board. The search should be conducted at the same point in the hiring process for everyone, and I would recommend that it's done after a live interview, simply because you wouldn't want it would eliminate the possibility of, being accused of not giving someone an opportunity to come and make a live first impression simply because of information that you discovered via social media. So my recommendation would be to conduct the social media search after the person has come in for an in-person interview. I would also make sure that the HR professionals, as I mentioned before, are aware of the state laws that should be followed and have a mechanism in place to stay informed of any updates or changes to those laws. And also make sure that the decision makers know that they can't make a decision yes or no solely based on information found via social media. Other factors should be the primary basis for the hiring decision, and any information discovered from social media should just be used with discretion and only to supplement the process. So in a nutshell, that's using social media in hiring decisions. So now I'll turn it over to David.
So in addition to gathering today to get the CLE codes, I assume a big reason why people have decided to log on today is to also understand the value that lawyers can bring to the business with respect to social media. And I would submit to you that there is tremendous value that both in-house lawyers and outside counsel can bring to the area of social media, because it implicates not only employment law and hiring decisions and the relationship the business has with its employees, but also it implicates consumer protection issues and advertising law and regulatory enforcement by the Federal Trade Commission. So it's an area that the regulators have spoken on, and one that implicates good data governance, whether it's determining what kind of content is going to be appropriate for sharing through social media, good data management and how decisions are made around what content's shared, and generally governance by management and how the controls are put into place with respect to the use of social media in the business. So although decisions around social media typically find themselves in the marketing department, there's really a huge opportunity for engagement by legal counsel in these areas, and it's one that's likely to continue to increase as the regulators continue to make statements about the use of social media. So the first part of this discussion, we're going to talk about recognizing the boundaries of regulating employees' personal use of social media. And we're going to talk a little bit about some of the recent NLRB decisions related to social media. We're going to talk a little bit about employee speech that does not relate to work, and we're going to summarize by trying to address what are some good social media policy takeaways. So as many of you may know, the NLRB has authority and regulatory responsibility in the area of social media, because Section 7 of the NLRB Act gives employees rights to organize, form, join or assist in a union, bargain collectively through representatives of their own choice, to act together for other mutual aid or protection, to choose not to engage any of these protected concerted activities, and rights that apply to speech on social media. And the NLRB over the years has issued a series of memorandums, first in August of 2011, second in 2012, and third in May of 2012. And these are available at nlrb.gov. And the most recent one was in March of 2015. And if you have not taken a look at these memorandum, they are very useful as the General Counsel for the NLRB goes through each of these policies in relative detail, in great detail, and outlines under each of the policies why they were not consistent with Section 7. And they continue, the NLRB continues to address the scope of permissible employer policies and workplace rules through the guidance that's issued by the General Counsel and the board decisions. So in May of 2015, the NLRB issued another guidance memorandum that gave examples of permissible and unlawful employer policies. And since that memorandum was issued, there have been a number of decisions that further explain how employer policies can run afoul of the National Labor Relations Act. And just as an aside, this issue alone is reason enough as the social media policy is being drafted by the organization, and whether within the organization this is the responsibility of a labor and employment lawyer, or even a function that's designated in some part to the HR department. It's another example of issues inside a company that require collaboration, cross-departmentally, and require input with the assistance of the attorneys through really two departments, both the marketing department and the HR department in some instances. So it's an example of an issue that requires alignment in the organization through legal and the business and operational units. So getting back to the NLRB specifically, the starting point for considering whether a workplace policy is unlawful under Section 7 and Section 8 of the Act, the case is Lutheran Heritage Village, Livonia, which is 343 NLRB 646, and it's a 2004 case that really speaks to Section 7 of the Act and saying that employees have the right to self-organize, to form, to join, or to assist labor organizations of their own choosing, and to engage in other concerted activities for purposes of collective bargaining or other mutual aid or protection, and that A1 of the Act makes it an unfair labor practice for employees to interfere with that, restrict them or coerce them in the exercise of those rights under Section 7. And so, to the extent that a private workplace policy violates Section 8 or Section 7 of the Act, the NLRB will have an issue with that. And so in the Lutheran case, the board really sets out, the obvious ways in which, the rule would be violated if there's restricted concerted activity. And really, even if the rule doesn't explicitly prohibit Section 7 activity, the rule violates the Act if the employees reasonably would construe the rule's language to prohibit Section 7 activity. And the rule was really promulgated in response to union and other Section 7 activity, or the rule was being applied to restrict exercise of Section 7 rights. So the guidance memorandum really begins, to apply this three-part test to workplace policies, and so the way in which these policies are drafted often becomes the trigger point into whether the NLRB will determine that the language meets this three-part test. So one of the cases that was recent in 2015 was Botch Imports, Inc., and that's 362 NLRB 83. And there the board concluded that the employer's social media policy violated the Act. The policy required employees in this case to identify themselves whenever they posted comments about the employer's business, or a policy issue. And the policy also prohibited employees from using the employer's logo in any manner. So the board looked at that language, and they found that self-identification requirement was overly broad because employees could reasonably construe it to cover comments about terms and conditions of employment. And the requirement to self-identify, maybe obviously, would interfere with the employee's protected activity that could occur on various social media outlets. So the board in that case concluded that a blanket prohibition on the use of a company logo was unlawful because employees would reasonably read the restriction on using the employee's logo in any manner to cover protected employee communications, such as engaging in union activity or while wearing a uniform bearing the company logo. So the second 2015 case that's of interest is one that was decided in March, Pierce 60 LLC, and that's 362 NLRB number 59. In that case, the board concluded that an employee that directed obscenities to his manager was engaged in protected concerted activity under the Act, and that the employer violated the Act when it terminated employment for allegedly violating the employee's harassment policy. The employee was a server working at a fundraising banquet, and there was a vote that was pending on union representation, which was scheduled to be taking place in a couple of days. And so as the employees were setting up for this event, the manager treated the employee and the employee's coworkers in a not-so-nice way, telling them, to stop chit-chatting them, ordering them to get spread out, and, it was loud enough for guests to hear. So the employee took a break, and he went to his Facebook posting and basically said some not nice things about the manager, some things about the manager's family, and he encouraged coworkers to vote yes for the union. So the employee hears about this posting, they learn about the posting, and they terminate him for violating the harassment policy. So the board in that case found that the Facebook posting was protected concerted activity, and they based that on the totality of the circumstances. And part of what they found as part of the factual findings, the circumstances included the fact that the employer had showed hostility toward union activities in the week leading up to the election by committing multiple unfair labor practices. And the comment was made on impulse in response to the supervisor's disrespectful remark. And the comments were posted while alone, on a break, and outside of the employer's facility. The comments didn't interrupt the work environment or relationships with customers, and the comments echoed employees' previous complaints about management's disrespectful treatment. And so of employees, and they encouraged employees to vote in favor of the union or representation. So again, very broad interpretation of what could be affecting that activity of the employers and the employees related to forming a union. The third interesting case really involves the overbroad confidential information policy, and this is a case that arose from Macys in May of this year. And an administrative law judge found that Macys maintained an unlawful employee handbook that contained overbroad confidential information policies. And the reason I share this is because this language could very easily be in a social media policy. In this case, Macys implemented several policies that contained language prohibiting employees from divulging the personal information. The language is the personal information of companies, employees, and customers. Information about employees, which if were known outside the company, could harm the company or its employees' confidential information such as names, home, office contact information, anything that's not generally available to the public or relates to the company's employees, their PII. And the ALJ held that the provisions in this confidentiality policy unlawfully restricted employees from discussing the terms and conditions of their employment, and further noted that these were really repeated throughout Macys' handbook, and that they would essentially reinforce the finding that employees would reasonably believe that these policies interfered with their rights under the Act. And the interesting thing about this case is that this case did not generate, as a result of any adverse action taken against the employee. The charging party in this case was actually the union that sought to invalidate the confidential information provisions in the employee handbook. The other sort of interesting thing about this case is there was a savings clause in the handbook that specifically said nothing in the handbook is intended to limit employees from engaging in rights protected under the Act, including protected concerted activities. And the savings clause was found to be insufficient and too generic, whereas the prohibitions on the employees were very specific. So those are a couple of examples of cases that have come along recently through the NLRB that focus specifically on language directly in a social media policy or that would affect a social media policy. So to summarize, social media is speech that is protected when it's concerted activity aimed at improving working conditions. You cannot fire employees for speech that's critical of the employer, regardless of whether it's speech that occurs at the office or on social media, and that your workers are permitted to discuss the working conditions, and there's some limitations in terms of rants or venting that portray the company negatively. But I think the takeaway from these decisions is once that draft is in place, how does it get reviewed and evaluated against the standards that the NLRB has set down? And as we talk more broadly about social media strategy and social media policy, this is one component of a good plan that has controls that have been determined by the business, by the legal team, that could be audited once a year to be certain that the policy is in compliance with the law. So certainly the relationship with the employees is a critical piece of drafting these policies. And finally, the employees can post on their personal pages controversial topics, and these are really protected forms of speech. So the components of what makes a good policy in taking the advice of the NLRB is that instead of simply saying that an employee can't disclose confidential information, it really needs to be defined with examples. And the watchword for drafting these policies is overbroad, is really being overbroad and not being specific. Policies should remind employees to disclose their affiliation with the company whenever they post about the company. There should be clear policies implemented that protect employee rights to discuss wages and working conditions. It should be clear that all communication on company-owned devices will be monitored, may be monitored. Prohibit inappropriate postings that include discriminatory remarks, harassment, and threats of violence or inappropriate unlawful conduct. And again, make sure you're drafting your policies in consultation with labor and employment specialists, especially before making a determination for disciplining an employee for something that's put on social media. So implementing guidelines for corporate use of social media, including platform-specific privacy policies. So we're going to talk generally about the considerations for the use of social media on behalf of the company, and then some platform-specific privacy considerations. So the first bullet point, on the list, the company's social media use is considered advertising and therefore must comply with the FTC requirements. As you heard Thalen comment earlier, the guidelines were recently updated, and what people are asking FAQ was released by the FTC earlier in the month of June. And it's interesting, and I think I agree with Thalen, that this is an area that's getting some additional renewed attention. And anytime the FTC begins to be more public or update things, it always creates a little bit of concern that enforcement is around the corner. And for anybody that's familiar with social media and whether they would recognize compliance under the FTC's rule, just sort of going through their Twitter scroll or feed, one wonders how quickly companies will begin to integrate some of this guidance by the Federal Trade Commission. So I want to go through a little bit of what the issues that were highlighted as part of that new guidance, and just to run down in the way of an overview since it's so recent. One of the things is contests and sweepstakes. If you're running a contest or sweep on social media channels, you have to provide some type of disclosure in each entry, and the burden is not on the entrant to the contest. The burden is really on the brand, and so the FTC was saying that the hashtag sweeps is really not enough. You need to be disclosing hashtag contests or hashtag sweepstakes. So one of the questions that was raised is, well, Twitter's only 140 characters. Aren't we really prevented from making detailed disclosures as part of these new rules? The FTC basically said, look, the words sponsored and promotion only use 9 characters, paid ad only use 7 characters, and you can start a tweet with hashtag ad, and that would likely be effective. And these aren't really mandates. It's only sort of providing an obvious disclosure about what it is. There was some discussion in this guidance about Facebook like buttons, and the FTC clearly said, purchasing buttons or likes from non-existent people is prohibited, and it's deceptive. So that's an area that you typically tend to see now being a focus of whether something's successful or not, is how many likes it has. They also got into employee endorsements. An employee of a brand or an employee of an agency promoting content on behalf of a brand, they have to state their affiliation in every social media post, sort of beyond their Twitter bio and Google Plus description, that it has to appear in all the posts promoting the brands or services of the employee or their clients. And the FTC has also indicated that employers are forbidden really from asking or incentivizing to post anything that's not true or that's not the employee's valid opinion, or to endorse a product or service that they're not using or unfamiliar with. Video endorsements, making sure that including a disclosure in a video description is not enough. The FTC wants to see clear and conspicuous disclosures, that they need to be at the beginning of the video, that they must be repeated throughout the video. So a lot of things in this new guidance, in this FAQ, and if you go to ftc.gov, you can find the FTC's endorsement guidelines. What are people asking? And there are a number of additionally new things that should be taken into consideration as social media is being conducted through the business. So, part of the strategy here is, defining who can participate in the social media postings of the company, and providing some clear rules for managing that content. And, the area of digital marketing, and given that it's new, in marketing generally, there tends to be some very aggressive work in these areas on behalf of the brands, and oftentimes, regulatory controls are not the area of focus primarily. So, trying to determine and really put some guidelines around who you have participating and controlling social media on behalf of the company is very important, and it's something that really shouldn't be left to really any one department. It's something that I think requires the input of the lawyers, invokes the governance apparatus of the organization around issues related to trademark and copyright and logos and rules for posting and the use of confidential information, employee privacy. There are enough issues here that it really just can't be left to chance. Ensuring that you're complying with all the specific terms of the use and user agreements for each of the platforms that you're using is another area where, like the NLRB and the decisions that focus on the use of social media, this is another area where there should be a control framework. If you're on Facebook, Twitter, Instagram, you need to be very clear on what the rules are around using those platforms. And just by way of an example, if you pull up the Twitter terms of service, one of the first things they say in the basic terms is, what you say on Twitter services may be viewed around the world instantly. You are what you tweet. And while that might not be especially compelling for purposes of the contract you're entering into with the terms of service, it is noteworthy in terms of managing the individuals that are posting on social media. The other area that you need to be conscious of, at least the Twitter terms of service as an example, is you're really responsible for the password. And Twitter's recommending strong passwords, because if that becomes compromised, you have a whole other set of problems. And then finally, understanding what's in the terms of service for your use of these platforms. Under the Twitter terms of service, you retain your rights in the content, but you're giving a license, a worldwide non-exclusive royalty-free license, to copy, reproduce, process, adapt, modify, publish, transmit, et cetera, all content in any media or distribution method. So, who you have determining what is the content that is appropriate to be tweeted is pretty important, because you're going to be distributing it all over the world. So, the idea would be that those terms of services and the platforms you're using, they need to be studied, and there should be a control framework that's developed around those terms to make sure that you remain in compliance with them, and that they're understood, and that you're not subjecting yourself to risk based on a potential violation of those terms and being able to not be able to use those platforms. The other sort of interesting thing about understanding the terms in use and the platforms and outsourcing the monitoring of those platforms to a specific department is how do you address when there's been either abuse on those sites by maybe a disgruntled customer or an employee, and you want to take down content. And oftentimes that can be a tricky maze as you go through the terms of use, and trying to determine how you kind of right the ship if someone's been critical of your business on social media, or you have somebody harassing the business. So, having a good understanding of the policies and violations of those policies. The Twitter rules and policies, there's 17 policies listed on their policies and violations page. There are 11 sets of guidelines. There are 14 ways to report a violation. So making sure that that's a component of your social media strategy, and how to extricate the business from something that may be critical or harassing is a really important component as well. I'm getting short on time here. So Phelan talked a little bit about crisis management. Again, where does the risk come from? We'll talk a little bit about the platform monitoring systems we just mentioned, sort of how to address a crisis. But there are a lot of examples, and the AP Twitter feed attack was one in 2012, and maybe you may be familiar with that. But this tweet of the hacked AP causes the stock market to drop 152 points when it was reported that there were explosions in the White House. So this is an example of just the tremendous power and attention that could be garnered from a misstep or a crisis related to your brand. But there are also examples of ways in which social media has been used through crisis management to more effectively communicate. So there are really two components to this for the business. There's one when the crisis is not of your making and how you communicate, and the second is instances where you're trying to get directly connected to your consumer to react to something that maybe doesn't especially involve your brand. So thinking through these issues ahead of time, much like breach or incident response, is critical. And how you disseminate information and how you react, and like I said, whether it's directly affecting your company or it's a reaction in the marketplace, those are things that really shouldn't be done on the fly. And there's probably tremendous value in sitting down and outlining, okay, if we had a hack, if we were being harassed, if we were accused of violating copyright with our content, how would we respond? So to give you a few other sort of points about, where does risk come from, many of you may have thought about this, but there's been research that shows that sharing about oneself on social media has the same pleasure sensations in the brain as eating food or earning money. So in terms of being able to make sure that your social media content is being effectively managed, I think you do have to give really careful consideration to who owns that on behalf of the business, who you're hiring to make those updates or put that content on, and make sure that it's closely monitored and there are procedures in place. Certainly the security pieces that would result in a hack are really critical and an important part of the equation too. And the other risk factors is not having any of this, frankly, is that there not being any clarity regarding what you're doing and what the goals are of social media, and sort of handing it over to someone in the marketing department that's maybe a couple years out of school or has some experience on social media. So there are real risks for the company that are involved here. So when dealing with company-owned social media, the employees who manage these pages should be instructed to monitor them regularly, report up on any appropriate behavior, closely monitor them, and the company really is responsible for all the activity on that social media page, and I think there's no shortage of examples of how that's played out. When dealing with personal social media pages, the employee should really be clear about the extent to which the company monitors those, and the company should be prepared to react to any issues that arise from an employee's personal page. And I think with that, I'm going to turn it over to Heidi.
Thanks, David. So we're going to now talk about transition from how you should and shouldn't have policies affecting the use of social media in the workplace to the devices that many employees are using both personally and professionally to make those social media postings and to do other types of business-related activities. One overarching theme that I want to reinforce here is that you heard both Dallin and David talk a lot about what your policies should look like, what your corporate policies should look like, what your external-facing policy should look like, and that's going to be a theme that comes up again in my portion of the presentation when we talk about actually how to go about using these devices and how they should be handled. So the first thing that I want to focus on is that this is a very rapidly changing space, mobile devices, and one size does not fit all. So what a program looks like, or what program may be appropriate for one organization will most likely not work identically in other organizations. There's going to always need to be elements of tailoring and customization to find the right program that works for you in terms of enabling your employees to be productive in a mobile environment. So the first thing is I'm going to go over a couple of different terms that I'm going to use throughout the discussion and the presentation. The first being bring your own device, or BYOD. And that's the most common acronym that you'll hear people talk about when they discuss mobile programs. And that really reflects exactly what it says. When employees bring their own personal device and access work-related resources from their personal device. The second model is corporate-owned, personally enabled. This is when the organization provides the device, but it's unlocked and unfettered so that employees can add any apps. They can do whatever they want in terms of surfing the mobile-based web interface. They can download and install apps and use them for email, alternative apps for email and chatting and games and social media and whatever else they may want, even though the organization or the corporation owns the device and in many of those models is also paying for the plan, the mobile device plan. The third acronym I'm going to use a lot is MDM. Sometimes also you'll hear MAM, Mobile Device Management or Mobile Application Management. And mobile device management is the idea that you have some sort of software that is remotely managing an app or data on the employee's phone. And the most common model for this is what's called containers. So for example, your organization will sign a contract with a vendor that provides MDM software. Your IT department will deploy the MDM software, and your employees will enroll in the MDM program. And in that model, the MDM will place what's referred to as a container on the end user's device. And in that container, which really looks like an app, will be multiple other apps that specifically facilitate doing work-related, business-related work. So an email, calendar, if you have specified apps for the type of business that you conduct, all of this will be located in the container that the MDM places on the device. Another model that often works through MDM or Mobile Application Management, MAM, is the idea of blacklisted and whitelisted apps. So some apps will be prohibited from being installed on employee devices, and some will be explicitly permitted to be installed on employee devices. And you may also have a situation where you have required or preferred apps for your employees. And this often comes into play in situations if you work in a regulated environment and, for example, you want to facilitate a mobile workforce, but you need to be keeping track and records of different types of communications, correspondence, and exchanges. So here are some BYOD and COPE fun facts, some statistics. These actually come from an April 2015, so a fairly recent survey that was conducted by Spiceworks Voice of IT, a social business platform for IT. And in their findings, 90% of organizations support at least one mobile device per employee. You'll often find plenty of organizations where employees will have multiple mobile devices. Some will have multiple phones. Some will have phones and tablets. So they may take various forms. 96%, so fairly high percentage, allow access to PIM from mobile devices. PIM stands for Personal Information Management, and that's what you will find most organizations primarily enable access to from mobile devices. PIM is calendar, email, note functions, sometimes an IM or a chat function, a mobile chat function, and the very basics just to sort of communicate, coordinate schedules, and message with colleagues and coworkers about work-related issues. Around 50% allow access to corporate applications, corporate apps, and or secure network resources. So these are more structured mobile device programs where there's a lot of security controls around who can access what, but they are facilitating access to more secured and restricted resources. 37% allow access to corporate file sharing accounts. So, for example, if you have a contract with a provider such as Box, a file sharing provider, that will be enclosed in the container or available through the mobile device program. 44% implement authentication policies, meaning there are certain rules, technical controls on how employees can access the content on their mobile device, whether that comes in the form of password restrictions or tokens or multi-factor authentication. And 40% of organizations implement mobile device management. This means that 60% of organizations that do this type of work don't necessarily have a formal MDM software. They're not using any extra software to control what employees are doing with their resources. This actually is sort of the origination of how BYOD became sort of its own field and its own issue, because there were certainly some savvy employees in the beginning who were able to understand how to use the settings in their devices, in their personal devices, to sync up and access email from their corporate servers, to link it directly into the corporate servers and access that on their personal phone. So I think it's important to understand that from an emotional perspective, that phones and mobile devices are not really treated the same way that PCs and laptops were, right? So this is sort of the evolution of mobile devices, and it's something to take into consideration because you will find very quickly, if you try and make rapid changes, that employees are extraordinarily emotionally connected to their mobile devices, their phones and their iPads and their tablets. So in the historical computer model, there were PCs, and nobody was taking their PC back and forth. It was a big, giant, heavy machine. It sat on your desk. Then we moved to laptops. And with laptops, people generally were used to having two. A lot of people still didn't bring their laptop home every night. They used it to travel for business. Maybe they were checking personal email on it or doing other work on it, but they weren't really using it in the same personal method that a phone does. And in some research and surveys that have been done about this, you know, the fact that people sleep with their phone next to them in their bed, it's the first thing they look at in the morning when they wake up, it's the last thing they look at before they go to bed at night, they're looking at it all the time. It has created a very different emotional connection to the way that people approach and use these mobile devices. So these are some things to think about as you either begin to develop or you revise your BYOD or your COPE programs. First of all, you want to factor in participation eligibility. Who is going to be eligible to participate in your program? Who are you comfortable with enrolling in the program? The second is going to be enrollment. And the third, data capture and retention. The fourth, tech support, how you're going to handle tech support. And the fifth, technical controls. And we're going to explore each one of these areas a little bit more in depth. So first of all, participation eligibility. Who needs mobile access versus who wants mobile access? This is a very important distinction. You might have people in your workforce who actually really need to be able to access work resources on the go. But you also are going to have people who want mobile access. There have been all sorts of studies and statistics shown that particularly younger members of the workforce, more recent college graduates, they have no issue with working long hours, but they want to be able to do it on their own terms and on their own devices of their choice. And that's going to be sort of your want category. They're going to want to be able to access their email, their calendar, their contacts, their notes, and understand what's going on when they're out of the office. You want to think about delineating who can access what mobile resources by their job role or function. Consider the types of data that are required for job duties. And this, again, I'm going to hit back to the policy point. You're going to find this where it integrates with your policy issues because you're going to have to actually figure out by policy for example, if you have an information classification policy, what resources, what data that you have that is considered sensitive or confidential or regulated can be accessed through mobile devices. You're also going to want to think about the primary workspace that for many employees and how that really is involved. So for example, here you'll see in some organizations, depending on what industry you're in, depending on your corporate structure, you may have field employees, you may have lab employees, you may have sales reps, people who by definition are on the go, they're not sitting at a desk. You want to provide them with access to appropriate resources, but you also want to think about, for example, if a lab employee is using a tablet to record to record experiment results and scientific data, which could also be intellectual property. How that tablet is going to be handled or locked down. Are you going to need to put extra restrictions on it, or are you going to leave it open so that while the experiment is running and the lab employee has some downtime, they can maybe play some games or hang out and chat and do personal email? These are all factors that you're going to want to consider when you are creating your program and deciding who's going to be eligible to participate in it. The next thing you're going to want to think about is enrollment. So again, policy, you're going to want to make it clear, and one way to make it clear is through a formal enrollment process to your employees what is involved with accessing these types of resources on the go. So you're probably going to want some sort of an application process. It doesn't have to be very formal or very heavy, but you might want manager approval so that the manager and the employee are both aware of who can access what resources when. You're going to want some formal acknowledgement and acceptance of the BYOD policy. So you first and foremost want to make sure that your organization has a BYOD policy that explains all of this and what is contained in the BYOD policy and what they are subscribing to by agreeing to be enrolled in the program. You're going to want to think about how, if it's mobile device management, if it's just setting up an email account through the native email program, how it should be installed on the mobile device. Very successful MDM and BYOD programs use screenshot by screenshot installation guides for their employees. So picture by picture, go here, adjust this in these settings, set this up, or alternatively, some organizations will actually have the IT staff help set up the device. You're also going to want to think about what policy requirements are going in on the device itself. So for example, you may want to impose certain passcode length or complexity requirements, timeout requirements for when a passcode is required again, and these are things you're going to want to think about when you structure your program. What type of information are you going to be capturing and retaining from participants in the program? So once you enroll in this, once your employees enroll in these programs, you're going to be able to get all sorts of information about them. You can collect lots and lots of information about them, or you can attempt to minimize what you're going to collect. But the number one thing is to understand what you're collecting and make sure the employee understands what you're collecting through their participation in the program. For example, are you collecting their location? And that can either be done if you are using a mobile device management software. So some vendors in this area are AirWatch or Good Technologies or Mobile Iron. If you've deployed one of these solutions, you're going to be able to tell from the device where they're actually physically located. And if you have app-level view into the device, the apps sometimes are giving off the location information, and you can identify where your employees are for the app. If you have a COPE model, a corporate-owned model, and you are paying the phone bill, you can also get an idea, not as precise as a device-based geolocation, but you can also still get an idea of where your employees are because you can see from the cell towers where they've made their phone calls from the details in the cell phone bill, in the wireless bill. Are you going to be capturing emails and records and logs of emails that are sent from the employee devices? Are you going to be capturing text messages? And are you going to be capturing what's referred to as the app profile? And that's the list of the apps that have been installed on the end user's device. This is a very important question. How far are you willing to let your help desk extend? So if you are allowing your employees to use personal devices or free and open corporate provided devices, are you comfortable with your help desk providing extensive technical support to the users of these devices instead of, say, sending them to their carrier store for help if something goes wrong or if they drop their phone in the toilet or something along those lines? Are you prepared to have your help desk be able to see and support all the devices? So there's two considerations here. One is the time and intensity of the support that you're providing. You know, are you willing to help with personal issues and troubleshoot with personal issues that are not related to accessing work information or corporate information? And two, the help desk, depending on the control set in your device, may be able to see quite a bit of personal information. And again, I'm going to draw the corollary to the social media discussion earlier and the need for explicit policies and informing employees of what's going on. Because, for example, if your help desk can see the app profile, they may begin to learn things about your employees that your employees were not prepared to disclose. The apps that a person has installed on their device actually reveal quite a bit of information about themselves. You can see if they're using dating apps. You can see if they're using gender-specific dating apps, which can reflect on perhaps their sexual orientation. You can see if somebody has, if somebody is sick, if they're using particular cancer tracking app or a diabetes type app. And in fact, I once heard a story from somebody who actually did have their help desk providing full support for personal devices for in a BYOD program, and the help desk person provided the support, then saw an employee who they provided support on eating a large dessert in the dining hall during lunch, and approached them and said, I noticed you had a diabetes app on your phone. Should you really be eating all those sweets? So you really have to think about not only what the people are being able to access, but also what they're going to do with that information. So you want to understand, first of all, the controls available to you through the mobile device management software that you opt for, if you decide to use any, and also what they're going to be able to see and how they're going to handle that information, and any confidentiality, extra confidentiality agreements that you may want people in that position to sign. The next thing you're really going to want to think about is the technical controls you're going to place on the device. Again, this actually is much more easily facilitated if you're using a mobile device management program to manage what is on the device. So the number one thing and the number one concern for technical controls is when will you wipe the device and how much of the device will you wipe. So as I mentioned earlier, MDM software provides what's referred to as containerization. So if you have a container that's managed through the mobile device management, all of the work, apps, and resources are contained within one sub-app or a container on the device. If a device is lost or stolen, or if an employee leaves the organization, through the administrative console, you will have the ability to wipe only the work-related data or whatever the employee may have put into the container. However, if you're doing a full device wipe, you have to disclose that also to your employees, because if they have not backed up their device, when they report to you that a device has been lost or stolen and you do a full device wipe, you will also be removing their personal contacts, their photos, their apps, and anything else that they may have put on the device. And this is something you're going to want to figure out and think about before you have people enroll in the program and put them on notice that this is what's going to happen. And this is why, another reason why this is really an important consideration. Because it has been shown over and over again that employees who are concerned or fearful that you will wipe their entire device are much more hesitant to report when it has been lost or stolen. And sometimes will go days, if not weeks, thinking that they will find the device themselves, and they do not use Find My iPhone or whatever to wipe the device themselves. And so somewhere out there is a device that has corporate information stored on it that has not been recovered yet and has not been wiped. And it's, again, it goes back to this psychological issue that people are very fearful of having their information and their data deleted. You're going to want to think about, again, the passwords, what's necessary. And if you have a more sophisticated and a more technical implementation of an MDM or other software, you can engage in what's called geofencing, which means when the phone enters a specific geographic area or a subdomain, you can lock down the functionality of the phone, or you can even track the phone more precisely when it enters that area. I think we did this one already. Yeah. I guess this slide came up twice. So one other thing that I want to talk about, though, really quickly on this slide that actually I didn't hit on before, so it's fortunate that it came back up again, is this issue, again, of data capture and retention. And I'll tell you a little war story. So I was on the phone with a client in a former life and doing some research and understanding, and I had on the phone the legal department and the IT department at the same time, and it was a client in a regulated industry where they needed to capture the communications under law between the employees and the employees' clients. And So they had set up a situation where the native text messaging, the native SMS app on the phone was logging and recording everything. And the lawyer said, oh, yeah, we have it all under control. Everything's under control. And while I was on the phone with them, his IT person who was administering the mobile device program, the BYOD program, interrupted him and said, actually, we know for a fact that not everybody likes the native text messaging app, and some of the employees are actually using third-party text messaging and SMS messaging apps to communicate with their clients. So there was a known portion of communications that should have been logged for regulatory reasons that were not getting logged simply because employees were going outside the system. They didn't like what was being provided to them, and so they were finding alternate means because the devices were unrestricted. So how do you go about creating a privacy-aware BYOD or COPE program? The answer is not simple, and again, it involves a lot of thought. It involves a lot of coordination between legal and your IT department, and making it clear what the capabilities are of the controls and what will be done and how it will be handled. But number one is you're going to want a BYOD policy, and in that policy, you're going to want to lay out what data is being captured, how it's being captured, what the help desk can see, and how and when information will be wiped, what the process is for informing when a device has been lost or stolen, and how that will all be handled. Secondly, you're really going to want a formal enrollment process. You're going to want to, again, require manager approval so that there's an acknowledgement on both sides of who has access to what data when, and a formal acceptance and acknowledgement of the BYOD policy.
Thank you. This is Brock Wanless with Groupon, and I'm going to spend the remaining time that we have left discussing some practical considerations when analyzing privacy and the mobile consumer interaction. And again, this is more the in-house perspective on how companies, particularly e-commerce companies, global e-commerce companies, tackle some of these issues. As I was talking to David and Heidi earlier, when we really have some sensitive topics to discuss or go over, we rely pretty heavily on outside counsel, smart outside counsel like them, to really kind of get in the weeds with us. But this little analysis should be helpful for those of you that are similarly situated and how you deal with these issues. So Groupon's a global platform. We have websites in over 50 countries. We have a mobile application or applications, some of which are native to certain countries and parts of the world. Others that are more global in nature that have different feature sets depending on user location. We're always tinkering with these products to make them better, to make them more attractive to consumers, and also there's considerations with different regulatory regimes around the world. You know, how do we maintain compliance with applicable laws while also providing consumers something that they actually want to use, et cetera. So the first slide you're looking at is sort of how we view high level some of these issues, and you'll see some very familiar themes here, and you'll also notice some things that aren't here, and I'll explain why that is. Location, information, purpose, notice, and choice. Those are kind of the things how the main features that we look at in evaluating how we want to roll out new products or add new feature sets to existing products. You'll notice what's not on there, and what's not on there is consent, and I'll explain why that is in a minute. But generally speaking, when we deal with issues like this, it's sort of presumed that at some point along the way during the user experience, we need to get some kind of consent, and obviously that varies depending on what it is you're talking about, what type of information you're talking about, what the purpose of that is, et cetera, et cetera. And so we can kind of wind up that discussion as we go. Moving on to the next slide. We'll talk about location, and here are some of the things that we take a look at and questions that we try to tackle. The location of the user is probably the most obvious in terms of what applicable law applies relative to the user location, tracking in particular, and what information is being collected. As I mentioned, you know, Groupon, by the very nature of our service, we do use user location in order to be able to surface to users relevant offerings, relevant deals. That's tied to your location. So without being able to know where you are as a consumer, particularly for using our mobile app, we're not going to be able to get to you deals that you think are interesting or that are even relevant to your area. How we do that? So we do that in a few different ways, but we have to be sensitive to a few different things here. So in terms of the device, obviously we're talking about iPhones and Androids mostly. Location is mostly controlled at the device level in terms of GPS, etc. In evaluating, how we address location issues in Europe, for example, we have to consider things under the EU privacy directives and applicable local law. Those can get a little interesting sometimes when you're dealing with one global platform and one app by and large. So we have to be very sensitive in talking to the product teams about really getting granular on how precise location is being used. How do we filter out user location to make sure the relevant consents are being not only presented but are also being worded correctly. We have some app level considerations relative to some new features that I think a lot of e-commerce companies are actually using now. One being beacon technology, others where consumer apps on user phones are talking to other systems to better inform the app provider of where consumers are in order to, again, to provide them a more relevant experience. Merchants. So merchants, a lot of people don't really think about this. Merchants are, in our world, how we use merchants, it's really any business that we're working with that may be running a Groupon offer or maybe using some other type of service that we use. Merchants are increasingly integrating with e-commerce platforms like Groupon and others to really get more valuable information about users, about customers, about their customers mostly, in order to better serve them to be more relevant. So that's another data pipeline that merchants are oftentimes collecting from users, and those are issues that we have to evaluate in terms of how we make sure users know that type of activity may be going on. And the central theme that I touched on in terms of location, when you're dealing with a global brand, operating globally and that is heavily integrated and using centralized platforms, it can be extremely difficult in sort of managing all the variances in local and continental law in terms of making these product decisions. So there is sort of risk balancing that has to occur here, and if you're in an in-house position, I think you probably know what I'm talking about in terms of how you explain what the law requires in terms of some of these issues versus what is in the best interest or what they think is the best interest of the business, and then making sure that our customers and our merchants and those that we are doing business with are taken care of in terms of their expectations. So location, for us anyway, and I think for many other e-commerce platforms, is really one of the critical things that we have to evaluate in terms of analyzing these sort of privacy implications with new products or features. Moving on, the second most important piece of the analysis for us is, really what are you collecting? And what we mean by that is what user information is being collected through the mobile device. There are lots of different ways and lots of different things that devices at the device level and apps at the app level can collect about users. Some of that can be sensitive information. Some of that will likely be considered personal information. Most of it is just information. One thing that we've learned here is that oftentimes, even though we're pretty ingrained in the legal department with what our product teams and engineering teams are doing, it's really sometimes difficult to assess where the risks really are without getting very, very granular with your engineering and product teams. And if you are an in-house lawyer, you know how difficult that can be sometimes in getting that visibility. If you're at a law firm and you're counseling clients, product counsel, privacy counsel, et cetera, in terms of how you get answers to questions you may be asking your client, one thing to keep in mind is oftentimes we don't really have much visibility into what the business on the back end is really doing. So there's some education that needs to go on in order to assess what's happening, what the plans are, what new products may be coming, to really get ahead of that. And in terms of just being very practical about how we go about doing that at Groupon, we really make a point to get to know our engineers, to get to know the product leads, the product managers, those that are actually driving these new features and products. So there's a level of trust there that they know that legal is not a blocker to business. I'm sure you've never heard that before, and that we really are trying to do what's right by the company. But again, getting granular on information collection can be a challenge. It can take some time to do, but ultimately at the end of the day, once the business sort of understands why it is you're getting into their business, they're more likely to cooperate with you. We mentioned consent earlier, but when it comes to, as most of you probably know, when it comes to the collection of personal information in certain jurisdictions, more affirmative type of consents are required. Getting those types of consents can vary in terms of how that's done, and is even more challenging now when you're looking at different types of devices that are on the marketplace. Wearables, for example, screens, mobile screens, they can be challenging at times in order to really convey to users what it is you're doing. There's tons of FTC guidance on this, of course, and there's guidance from other regulatory bodies and self-regulatory bodies, but again, it's a challenge trying to determine really what in our view, or what in the business's view is appropriate consent, what the user expectation is, versus what a regulator may think is appropriate. There is often a wide gap there. What we try to do as a very practical matter is sort of figure out where that balance lies, and really at the end of the day defer to what we think is in the best interest of our customers in terms of what they understand about what's going on. Mentioned briefly, obviously there's certain types of information that is a little more sensitive that you need to be thinking of, particularly when it comes to precise location. And there's been some new laws passed recently in Europe, Netherlands, for example, with cookies. That require a little more affirmative consent with a more explicit disclosure. So again, you really need to know what it is you're collecting and how you're getting those types of consents. Moving on to the next slide, why are you collecting this information? And this is kind of an odd, I think, a data point to throw in here for an attorney. It doesn't really matter why you're collecting it. I mean, we've been asked that question before from the product teams. Well, why do you really need to know? All you need to know is what we're collecting and where. You should be fine. From our perspective, we try to get very, very granular and embedded with the business. We want to know why you're doing this. We want to understand the business need, the business purpose, because that helps us analyze more fully, what risks are really there, what it is you're really, as a business, trying to get at. And maybe we can come up with some better ways of doing this that may not have been apparent at the beginning of the conversation. In terms of the legal analysis that's there, some of the purposes for this information, it doesn't necessarily apply to what we do at Groupon, but there could be some purposes for why certain entities would want access and collection of certain information that may be a little less I don't know, how should we say, a little less forgiving when it comes to, under the law, when it comes to collection and use of that information, but that really doesn't touch upon the things that we do. I'm sure many of you at law firms have probably come across some scenarios like that, but again, getting into the purpose can really uncover maybe some other issues you haven't been thinking of, and can really help you better understand what the business purposes are in terms of new product development and the evolution of those same products. I throw in here at the last bullet, is this information being shared across borders with third parties? That's obviously a safe harbor consideration, and whatnot. But the issue for us there is because, again, we are a global company with data transferring borders, crossing borders all of the time. We really try to keep very good track of what's coming from where and its use, so we know how it should be managed, how it should be controlled in terms of access controls, and those types of things. Moving on to the next slide, notice. Notice is pretty, as many of you know, is a pretty straightforward concept. There are a few things that come to mind here, though. Obviously you have a privacy policy that outlines or should outline anything and everything that the mobile experience with your app entails, what information is being collected, what it's being used for, what your rights are, et cetera, et cetera. There's an evolution in the law, of course, in terms of what explicitly needs to be in those policies, what they should say, should they be written more clearly. That's always a tension with any of these issues. Cookies policies, that's something that sort of is required now in the EU, and we use one globally, frankly, just so we put users on notice, more notice in terms of what it is we are doing with first-party and third-party cookies. And we can talk a little bit more about that in a second. Just-in-time notices, disclosures on mobile, that really means push notifications and in-app notifications. There may be some beacons out there that will elicit an app push for certain in-store deals. If any of you have ever played around with an app that's actually been integrated with an in-store beacon technology, it's kind of interesting to see how that works. Precision and prominence of notice versus mobile space constraints. We mentioned this a minute ago, but this is really something that I think the industry, particularly with the iWatch, the Apple Watch, and some other wearables, is really going to struggle with in the coming years. We recently, yesterday, as a matter of fact, finally released our first Groupon app for mobile. For the iWatch. And it's interesting to see how the screen limitation really limits what you can do with displaying certain relevant terms and conditions and notifications. But again, that's going to be an evolution, I think, in the law, and particularly as the FTC starts to think about some of these issues. But the way we've wrestled with that is, again, erring on the side of caution and trying to make it as transparent to consumers what's going on, with the backup being the phone that is actually connected to the watch itself. The next slide, choice. Sometimes notice is sufficient. You really don't need to provide an explicit choice or consent mechanism. But again, customers like to know what their options are, right? So we try to explain as detailed as we can what it is their options are when it comes to privacy, when it comes to location, when it comes to cookies, when it comes to other things where choice is either required or we feel that it's in the best interest to offer that kind of choice. Obviously, there's certain things that we need to provide more choice for, and that means more detailed and affirmative consents. Geographically speaking, that can prove to be a challenge when you're talking about an app that is mostly North American centric. So, there are things that we need to do to be more compliant in Europe versus some other regions of the world. But again, we wrestle with those as those issues come in, and thankfully we do a pretty good job of planning for those considerations and making sure that as laws change and frankly become a little more restrictive globally, that it's not too big of a headache for us to build in some of these mechanisms because they already exist. Moving on to the next slide. This is more of a practical slide that I wanted to throw in here just for folks that may be doing some of these things on a global basis. Groupon's a pretty big organization. We operate in over 50 countries across 6 continents. We have a lot of different operations internationally, many of which we've acquired through acquisition. So we have a lot of legacy systems, a lot of new platforms, and of course there are cultural and language challenges anytime you're dealing with an international business. For us, the product development is led out of the U.S., scaled in North America, then introduced globally. So the way we handle rollouts internationally is we try to stay in pretty close contact with our colleagues, the continents, EMEA, LATAM, and APAC. And we feel over time we finally figured out how to do that effectively. And for those of you that are in-house, you kind of know what I'm talking about. There can be challenges to doing that cross-border. You have time zone challenges, you have language challenges, you have cultural challenges that can make coordination on these types of sensitive issues very, very challenging. But over time, we've sort of figured that out. we have a pretty good team of attorneys and product teams now that sort of know the drill in terms of who to call, who to loop in, what issues are really going to be prominent, and we feel it's taken 5 or 6 years to kind of get there, but we're in a pretty good place at this point in terms of how we tackle some of these global management functions. For us, and again, these are just some tips that we've learned here by experience, sometimes the hard way. So the most important thing you can do is to really get to know your product teams and stay engaged. Getting to know people is hard to do when your engineering teams may be based out of a different office, maybe a different city, different time zone than you are. But it's possible to do with technology. It's easy to email, it's easy to phone call. If you have the ability to travel, visit these people in person, get to know them and earn their trust. Because the last thing you want to be is a privacy counsel or a product counsel that is the last to know when new product is coming on or new features are being rolled out, and that's not really good for anyone. And for us, that simply doesn't happen because we've done what we can to get to know these teams, and they trust us. Get to know your colleagues. And what I mean by your colleagues, particularly your international colleagues, are those that are overseas and that you rely on to make sure that you're in the know about what's going on, what issues they're facing, and to keep them in the know about what new products may be coming so they can start thinking about how this may be rolled out in an international scope. Not to put a plug in for anyone on the phone, but find good outside counsel, and what I mean by that is find someone who actually understands risk and understands your business and isn't going to give you the textbook law school answer. You need someone who can be a little more practical than that and have a backup. So you never know when you want a second or third opinion on some of these issues, and because a lot of the things that we deal with are really on the cutting edge of the law, and these are evolving spaces, it's good to bounce new ideas off multiple counsel and sort of make your own decision from there. And lastly, put in place clear internal guidelines on how PII and other sensitive user information is handled and used. Thankfully, at Groupon, we've had a lot of these guidelines in place for a long time. We had some good lawyers when the company started that were really privacy-centric. So we've done a good job of sort of locking down how data is used and transferred and handled. But that's something that I can't stress enough for anyone that counsels startups out there that are handling massive amounts of data. You need to have these controls in place. And to get there, it may take some effort and some work, but it is definitely worth your while. So I think that's my last slide. I believe we have some time for questions.
Yeah, so this is David again, and I've been appointed the responsibility of being the moderator. And I will answer the first question. There are a few others that I think we should get to. So the first question is, what's the potential liability of a company that accesses employee texts or personal emails on his or her smartphone? And I think we're in the land of potentially a violation under the ECPA, which is the Electronic Communications Privacy Act. And Title I of that act makes it illegal to intercept electronic communications, but Title II, which I think is the more applicable one here, is the Stored Wire Communications Act. It makes it unlawful to access stored communications without authorization. And for anyone that's still taking notes, that's 18 U.S.C. 2701. And for violating that statute, there could be fines, potential imprisonment, depending on how malicious it is, but a successful plaintiff could be awarded actual damages, any profits made by the violator, but in the event not less than $1,000 in terms of fines, compensatory damages, punitive damages, and attorney's fees. So there are penalties for unauthorized access. This one I think is for Heidi.
I just want to actually just to reinforce what you just said. That is everything that you just said is I would have said the exact same thing. However, it's the unauthorized piece that's really important. If you have a program in place and your employees have consented and you've made it clear what you can see as the company and your employees have an understanding and have signed the policy that that information can be accessed by the company, then ECPA does not come into play.
No, thanks for that qualification. Good follow-up explanation. So unauthorized is what gets you into trouble there. Heidi, do you want to take the next question?
My screen froze, so I can't see what the next question is. So can you read it to me? And then
Oh, sure. Are there specific laws governing employers' access to employees' personal emails, text messages? Oh, I'm sorry. Did we just read that one?
Well, it was a different question.
No.
So there's,
Okay.
there's a variation on it, and actually I'll answer that and the next question together, because the next question was about EU issues. And
okay,
so,
sure.
Yeah, the quick answer is that ECFA is certainly something you want to be aware of in that situation in terms of unauthorized access or not having consent from your employees that information can be accessed. But more so than just the data itself, there are some issues when you get into the international scope, to the point that many of the MDM vendors have different modules and settings available for EU-specific, country-specific for within the EU, about the hours within which email will be pushed to the device. So as to accommodate issues like overtime, there was a tech workers union in France that negotiated, their phones should not receive work-related email after a certain time. So there certainly are country-specific and EU-specific guidelines for implementing these programs, and you do want to be familiar with them. The second thing that is related to this is that you, much like many other areas of privacy, be careful and don't collect more than you need or want, because the sort of quintessential example in this situation is if you are collecting all of that information and you know where your employees are and who they're communicating with and what they're saying, let's say that somebody gets into a very nasty divorce battle and the non-employee spouse suspects that the employee spouse was cheating on them, their very intrepid attorney may come asking you for logs, documents, and information about who the spouse has been communicating with and where they've been when.
Great.
And I think at that point we're probably out of time, and I thank you on behalf of LexisNexis to Fallon, David, Heidi, and Brock for an outstanding program today. For our attendees, please take a moment to complete the survey, as it gives us excellent feedback to continue to bring you programs that you want to see the most. Also, be sure to indicate in today's survey if you would like to receive a complimentary copy of Mealy's Data Privacy Report. Thank you all, and have a great day.